Please have a seat. So, the court has two additional arguments today, and I understand that the first one we're going to be hearing is number 244466, United States versus Aborasadeh. Am I saying that correct?
That's correct, Your Honor.
Thank you. And Mr. Block?
May I proceed?
Absolutely.
Good morning, Your Honors. May it please the court, Jeffrey Block on behalf of the defendant appellant, Mr. Aborasadeh. This court should reverse the district court's denial of Mr. Aborasadeh's Rule 29 motion because he did not present under oath any materially false statements in a document required by the immigration laws or regulations. I'd like to first begin with the required documents element. Under 1546...
Mr. Block, before you do that, can I just, I'm 99% sure I know the answer, but you have two sort of different arguments, as you're about to say. Am I correct that either one of these is an independently sufficient basis for you to win?
That's correct, Your Honor.
Okay, thank you.
So on the required documents element, Your Honor, which I'd like to focus on first, under 1546, it is not a crime for an individual.
I'm so sorry. Please go on.
It's not a crime for an individual to present a materially false statement unless that statement is made in a document required by the immigration laws or regulations. And as we explained in our briefs, no court has ever held that optional documents filed in support of a VAWA self-petition are required documents for purposes of 1546A, and with good reason. The text of the statute, the regulations, the case law, and even the Form I-360 itself show that no other documents are required to be submitted with a VAWA self-petition.
So can I just, again, explore what that would mean? So let's hypothesize, just for the sake of argument, that you were correct about that. That is just saying that the stuff that your client did here would not violate that specific provision under which he was convicted. It wouldn't even necessarily say that the conduct might not violate some other federal criminal statute. I'm not asking you to, of course, confess that your client is guilty of some other, but it wouldn't foreclose it. It would simply be a holding the conduct is not a violation of this particular provision.
That's correct, Your Honor. I'm focused only on 1546A, okay. and certainly it is possible, for example, for someone filing, either making or presenting a VAWA self-petition to be criminally liable for materially false statements. For example, 8 CFR 204.2C6 requires the submission of the Form I-360 itself. So it's our position that if you make a materially false statement in the Form I-360 itself, that is punishable under criminal law.
And it's either the statute or the regulation. It also specifically says making a false statement on an affidavit is independently a violation of the statute too, right?
So the statute does distinguish in 1546A between the application, which here is the I-360, an affidavit, and other documents.
Required to be submitted by law.
That's right, Your Honor. Although our position is that no self-affidavit is required to be submitted along with a.
But we wouldn't have to answer that question either. So the question then would be is it all affidavits or only required affidavits, but there's nothing about this case that would require us to resolve that question?
No, Your Honor, and the text of 1546 distinguishes between the application, the affidavit, and the other documents, and we explained on page 23 of our opening brief that these other documents, the psychological forms and lease agreements, they're not considered the application, they're part of the other documents language in 1546A, and the government doesn't dispute that. So the psychological evaluations and lease agreements are other documents. They're not required by the immigration laws, and you can look at 8 CFR 204.2C numeral 1 and numeral 3, and you can also look to the trial testimony, and I'd focus on just 2 points. First, if you look at JA 550, that's testimony of Officer Kenny. She admits at trial that there are no specific required documents for a VAWA self-petition, and the same is true at JA 1676.
But do you think that's a question of fact or question of law? It seems, I'm open to being wrong about this. It seems bizarre that we would ask a jury to find as a matter of fact what documents are required as a matter of law. That seems like a legal question.
It does seem like a legal question. It certainly is at best a mixed question of fact and law. But
and that you'd have a judge this goes back to the government's argument that this is really a motion to dismiss the indictment, because you could look at the indictment and the indictment says what the documents are, and they could say, well, if the view is those documents are not required by law, defendant can move to dismiss the indictment because as a matter of law, those documents are not required to be submitted.
So 3 merits points on that, but just before I get there,
sure.
I don't think this court needs to resolve the question of whether or not this needed to be addressed first in a Rule 12 motion, and that's because the government waived this argument.
Forfeiture?
Exactly. When Mr. Borosade presented his Rule 29 motion to the district court, the government didn't object that his required documents argument was forfeited or waived. And so under Linder, the government has essentially waived the waiver argument. But as to the merits of your question, Judge Heitens, there are really three reasons why we don't think Mr. Borosade forfeited or waived his required documents argument by presenting it through a Rule 29 motion. The first is that...
Oh, no, we can come back to that because I'm going to ask the government why they haven't obviously forfeited the forfeiture. So you can, if you want now, use your time to explain why you think you're right on the merits.
So on the merits of the required documents argument itself? Understood. So the regulations are clear that lease agreements and psychological forms are not required documents. And the government's position, and I think if you look at page 25 of the government's brief, there it essentially argues that under its view of the law, anytime a material fact is presented or made in a document, that document is itself required. But 1546A has two independent requirements that are both at issue here. One is a materiality requirement that goes to whether or not the false statement relates to an eligibility requirement, i.e. is it material, and the other is whether or not it's presented or made in a required document. But the government's arguments render the required documents element a nullity. Essentially, under the government's position, any time a materially false statement is made, it is necessarily transmitted in a required document. And we think that's inconsistent with Congress's intent in creating a statute that has two separate elements. One is materiality, and obviously one is the required documents prong.
But help me understand, because under the regulation, it also, if you look at the portion that deals with the prima facie determination in the regulation, it says that you have to have the supporting documentation.
So there are certainly regulations that say that you need to submit something in order to support the evidentiary requirements. But we believe there's a distinction between the eligibility requirements, which goes to the materiality prong. And that's why Mr. Borosade does not contest the materiality of the lease agreements and the psychological forms, because those relate to eligibility requirements. But there's a separate question about whether those particular forms are required under the immigration laws or regulations to be submitted.
So could I give you an example that at least in principle could this work? That a self-petitioner submits the form, the required form. A self-petitioner submits an extraordinarily detailed and thorough this is why I asked you whether we could wall off the affidavit question. The self-petitioner submits an extraordinarily detailed and comprehensive affidavit that, amongst other things, explains why he or she cannot provide any other documentation because of the sort of concerns that gave rise to VAWA and this whole procedure in the first place. That application wouldn't be dismissed as incomplete, would it?
No, Your Honor, and actually if you look at JA 1681, again, that's expert testimony from Officer Arnell, she says that the self-affidavit for a VAWA self-petitioner is enough. So, something more is required other than the Form I-360 itself. But for many VAWA self-petitioners, my understanding is they may just file the Form I-360, a self-petition, and that's all that the package is going to have. And again, that's consistent with the regulations. 8 CFR 204.2 C21, a mouthful, does say that they're asking for any evidence that might be relevant. And so as long as the self-affidavit addresses all 8 of the eligibility requirements, that's sufficient. You don't need to submit any other documentation. I hope that answered your question, Judge Benjamin, but I think ultimately there is nothing in the record here that shows that these documents are required by the immigration laws or regulations, and we think that this court can address it just on the text, regulations, and the case law itself. And I think one thing I'd like to focus on the case law briefly is this court's prior decision in Ryan and Webster, which I think is the most on-point circuit case. There, the question, that case dealt with employment-based visa applications and 2 specific forms, a Form 750 filed with the Department of Labor and a Form I-140 filed at the time with INS. The issue in that case was the defendant argued that neither of those forms was required because by themselves it could not create a favorable change in immigration status. And what this court said was that they're required under 1546A because you cannot receive an immigration-based visa without filing the Form 750 and without filing the Form I-140. And that logic doesn't apply to the psychological forms. A VAWA self-petitioner can achieve a favorable change in status without filing any other documents, including the documents that are at issue here. Unless this panel has any other questions on the required documents prong, I'd like to move on to the oath requirement.
But the VAWA, they would need to file an application, right? They would need to file some document. So it's not that there are no documents, there's just not these specific documents.
So it is correct, Your Honor, that you need to file both the Form I-360 and something else. But we think that the fact that there are eligibility requirements which must be fulfilled through some ephemeral documents does not mean that there are any required documents. And that's because, again, there's
But they were required in the instances in this case. In other words, your clients, I guess, would not have been able to prove eligibility, or they used certain documents in order to prove eligibility. And so once they used those documents to prove eligibility, they were required for those specific petitions. Maybe not for every petition, you don't need the same documents for every petition, but for the specific petitions that your client submitted, or that your client's client submitted under oath, the documents that were submitted were required, because otherwise they wouldn't have been able to prove eligibility. And so why can't we hold that in the instances that your client was involved in assisting, there were documents that were submitted that were required for purposes of those specific cases that were required in those specific instances, without our holding then essentially bleeding over to a holding that in every single VAWA case, you need to submit those specific documents?
I think it goes back to our point, Your Honor, that there has to be a difference between the materiality element and the required documents element. And if it is the case that any time a document is submitted that relates to any eligibility requirements, that it is necessarily required, then those two elements are not distinct at all. They're being treated as the same. But the way we read the statute, Your Honor, is the law only criminalizes materially false statements. And so you're right, because the lease agreements and psychological forms address eligibility requirements, they're certainly material, and Mr. Borsade does not challenge that. But then there is a separate element, which is the required documents element. And there is nothing in the regulations that require the submission of any specific documents. And that's how we read the statute.
And I'm not sure I read once again, looking at a prima facie determination, it says the Form I-360 and other evidence supporting all of the elements required of a self-petition in paragraph C1, which takes us back to the eligibility. And so I'm not sure how you can get past the prima facie case of eligibility without the supporting document. It doesn't say or, it says and.
Well, you're certainly correct, Judge Benjamin, that something more is required other than the Form I-360. We don't dispute that, and that's similar to the conversation I was having with Judge Haytens. It's you need to file something, but the fact of the matter is that neither the psychological forms nor the lease agreements are required documents. And I think if you look at the instructions of the Form I-360, they're helpful. The Form I-360 on its face says that if you do not file any required documents, your petition may be denied. And then when you go look at the instructions for a VAWA self-petition, there are no required documents. And we made this argument in our blue brief, and the government responded basically—
No other requirements beyond the application.
Exactly, Your Honor. There are no specific required documents. We raised this argument in our blue brief, and the government's response was essentially that the instructions don't matter. You need to look at the text and regulations.
So is it basically the choice is either the only required documents are those that the statute or reg literally says you have to do, because if you don't do these things, your application is literally not complete, or to say any document that an applicant attaches is transformed into a required document? I think that's the choice I'm asking you.
I would just add just a little bit of clarity on your first point, Your Honor. Our position is not that the regulation has to say only this particular form. I think if you look at, for example, the government cites this Konstantakos case, which is about performance visas, and that's an example where the regulations say you must submit 3 of these 6 following documents. I think we'd concede that in that situation where a statute says that you need to pick 3 of 6.
The three you pick are required?
That's right, Your Honor. But in a situation like this where the regulations just say we encourage you to submit any relevant testimony or any relevant documents, and we encourage you to submit evidence that you, in this example, lived with the abuser, that's not a required document. And otherwise, under the government's approach, the materiality element and the required documents element, which must be treated as independent and given their own meaning, don't have any distinguishing factors.
So our questions have prevented you from getting to issue 2, so I'm going to give you some leeway. Would you like to address issue 2? I will do the same for the government if they need extra time to make sure they address all the issues.
I'm happy to do it briefly, Your Honor. On the issue of the oath requirement, our view is that the statute as written, and particularly the surplusage issues created by the government's reading of it, result in a kind of an absurdity if we take the government's position. Since 1924—
Well, can I ask you why you don't have a massive waiver problem on issue 2?
So for that, I imagine we're talking about the Rule 29 waiver,
Yeah.
Your Honor.
Yeah.
It is true. It is true that trial counsel erred in not renewing it after the defense case was made. We'd argue that two things on this. First,
You said the futility.
That's
so
right.
question one, has this court ever said there is a futility exception to Rule 29?
no, Your Honor, it's not. So we're asking this court to adopt the futility exception, and we think this is a great vehicle for this, where the district court's denial of Mr. Aborisade's Rule 29.
Just feels like that's an exception that's going to swallow the rule really fast. Like, I mean, because I made my mid-trial motion and the trial judge said, I'm not feeling it. So therefore it'd be futile, so I don't have to make it post-trial. Like, I just feel like this exception would instantly swallow the rule.
I disagree respectfully, Your Honor, and I think that in this instance, the government's argument relies entirely on a fictional waiver. I mean, of course, waiver is here to encourage litigants to fully brief their issues before the district court, to allow the opposing side to chime in, for the district court to have the first opportunity to rule on the record its view of the law. And in this case, all of that happened. Mr. Aborsade filed both an oral and a written motion. The government had its chance to respond. The district court took time to review all of the case law in this case, and it came out.
I just feel like I could say this about a lot of Rule 29 motions.
And even if this court has some skepticism about the futility exception, we still think you apply de novo review to this issue, and that's because the jury instructions that the government proposed, which is at jury instruction 27 and jury instruction 30, required the government to prove beyond a reasonable doubt that Mr. Aborsade was the individual who presented these under oath.
So the government in its jury instructions stipulated to the legal requirements?
That's right, Your Honor. If you look at jury instruction 30, that requires the jury to find that the defendant, Mr. Aborsade, presented these statements under oath.
But the only reason we're here is because the jury found him guilty, right?
That's right, Your Honor. But I think consistent with this court's doctrine on an invited error, we think that a party cannot ask the district court to adopt a legal standard and then take a position.
Oh, I agree. They now can't say that the jury instructions were legally wrong. I guess they probably can't say that. Or that the district court erred in giving that jury instruction.
So, and that's exactly why, Your Honor, we think that this is a waiver by the government, that the government proposed this legal standard that Mr. Aborsade, that the government needs to prove that he presented these under oath, and thus, even if we have a waiver of the Rule 29 motion, where there's a waiver on both sides, this court can exercise its equitable discretion to review this issue de novo.
Do you want to spend a minute on the I pushed you into forfeiture. Could you talk about the merits of that issue?
Very briefly, Your Honor, I'll try and wrap this up. I know I'm over.
You're good. You don't have to apologize. I'm the one who's giving you more time, so.
We believe that the court in reviewing the text should apply not the last antecedent canon, but the series qualifier canon, and we think that's because of two parts of this text. First is the fact that there's a parallel construction between the makes clause and the presents clause, and when Congress added in the presents clause, it nested it into the fourth paragraph of 1546A, and the makes crime and the presents crime should be read in parallel. But the other issue, and this is exactly how the Ashcroft panel reviewed it, is the Ashcroft panel said, we have some skepticism about that interpretation. We typically apply the last antecedent canon, which in that case would not apply the oath requirement to the presentment clause. But the surplusage issues created by that interpretation are so serious that we don't know what Congress intended. And I think that's exactly the way that you can review this, is Congress in 1924, when it enacted this statute, it has, since the enactment, has always required an oath requirement for a makes crime. And the government's argument is essentially that in 1952, when Congress added the presentment clause, it eliminated the oath requirement, at least in situations where the individual who makes the application is the same person who presents it.
So wait, but, okay. So sentence one, sentence two, so the makes and presents. Why isn't Judge Hollander in the Second Circuit basically just right of that this is thinking really hard and making things more complicated? Because, am I right, the makes crime, right, what they did is it said, I'm doing the classic thing of not looking at the statute that I'm asking you out, but the makes crime, there's two ways you can commit the makes crime, right? There's an amendment to the statute. Could you remind me? I'm so sorry. Remind me, the two ways you can violate the makes clause are what?
So the two ways you can violate the statute are either making a false
No,
statement.
I understand that. I know makes and presents, but then but the statute has two different ways you can violate the makes, right? That there's the language they added. I'm going to try to find it. I'm sorry. So makes under oath, or as permitted under penalty of perjury under Section 1746 of Title 20, knowingly subscribes as true, right?
That's right, Your Honor.
So those are two different ways you can violate the makes clause. In fact, they added that second part of the language to broaden the makes clause. That was the point of the amendment, that broadened the makes clause, right?
I suppose that's true, yes.
Okay. And then there's the presents clause.
That's right.
And the alleged superfluousness identified by the Third Circuit is to think that, like, what happens when the person who makes is the same person who presents?
I think Ashcroft's a great example of that, Your Honor. In that case, the defendant was indicted as a maker of a false statement.
Right.
Then the government realized that no one signed the form, so they just charged him as the presenter because they claimed that there was no oath requirement. And so at least every time the maker and the presenter is the same. And in Ashcroft, the government represented that they are usually the same person. I know there's been some debate about whether or not that's...
But we certainly don't agree they're always the same
They're
person.
not always the same person, but in instances in which an individual submits their own immigration application, the government would then always charge this crime as a presentment crime and totally read out the oath requirement to the maker.
I mean, but isn't the other way to fix that superfluousness to say that the presents option doesn't exist when the person who makes and presents is the same person? That clause 1 is about the person who makes, regardless of whether that person also makes and presents, and that the presents crime is designed to deal with people like your client, the person who doesn't make but does present. And it seems totally sensible to say, if you knowingly present something that you know has a false statement in it that's material, you're liable. And I don't care whether you were under oath. If you turn something in that you know has something that's materially false in it, you're guilty, whether or not you did so under oath. That seems like a totally sensible crime.
It is one way you could certainly read the statute, Your Honor, but I think consistent with the Third Circuit's approach where it found the statute grievously ambiguous, there are a number of ways to review the statute, and given the fact that Congress in 1924 enacted this as the making statute only, and at the time, there was no presentment clause.
And then we're confronted by people like your client and go like, but what about a situation where the person who turns it in isn't the person who did it? Shouldn't that be a crime too? And they say, yeah, I guess that probably should be a crime too.
That's correct, Your Honor. There's nothing in the legislative history that...
In other words, to think, like, the only way the presentment clause has any meaning independent of the makes clause is if it is designed, at least in significant part, to cover this situation where a person presents but did not make, because otherwise the presents crime would be completely subsumed by the makes crime.
We certainly agree that the presents crime and the makes crime are distinct acts, and Congress sought to expand the scope of 1546A when it added this so that individuals who present a false statement to USCIS can be held criminally liable. But in this particular instance, we don't think that there's any clarity about what Congress is doing with the oath requirement itself.
Okay. I have gone you over time, but I will ask my colleagues if they have any questions. Okay, you'll have some time in rebuttal, and we'll give you your full rebuttal time.
Thank you, Your Honor.
All right, we'll hear next Mr. Bornstein? Bornstein, okay. Whenever you're ready.
Good morning, Your Honor. May it please the Court, David Bornstein on behalf of the United States. The defendant, Mr. Borisade, provided fake documents to people who were self-petitioning the government for immigration relief. He believes that he can evade criminal liability for his knowing fraud against the government for 2 reasons. First, by taking a self-servingly narrow view of the immigration fraud statutes required by element, and next, by taking a self-servingly broad view of its under oath clause. But neither position can withstand the plain meaning of the statute's text or basic rules of grammar, and for those reasons they fail. But this court should not even reach the merits of those claims because the defendant has waived them, making that the most straightforward means of resolving them. So unless any member of the panel would like to turn me elsewhere, I'd like to begin with waiver.
Yeah, I'd like you to explain to me why in issue 1 the government hasn't dead forfeited a forfeiture argument. I mean, the government constantly invokes forfeiture against criminal defendants in ways that are extremely adverse to them, and in response to well, that seems really harsh, the government's like, yeah, but I know, but rules about when you have to make arguments, they're really important and we gotta follow them. And this has a little of what's good for one is good for the other to me, so why have you not dead forfeited your potentially winning forfeiture argument on issue 1?
Sure. First of all, we raised it in our response brief. Second,
No, I'm sorry, you forfeited before the district court, because when he raised this at Rule 29, you could have said, whoa, Judge, this is like this. I mean, so let me give you an example. If a defendant mid-trial made a motion to suppress evidence for the first time, I would expect virtually every assistant United States attorney that I've ever met to say, whoa, 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 the rules are very clear, pre-trial motion only, judge, you literally can't even hear this, right? And that's a fully sufficient reason to deny what he's doing right now. And in response to this happening here, the government was like, no, he's wrong on the merits.
So, two reasons, Your Honor. First, there's Pittman, which Your Honor authored, in which it is on all fours here. In Pittman,
Not at all. The government did not raise forfeiture. The defendant in Pittman did not say the government had forfeited forfeiture. I've gone back and looked at the brief.
that is true, Your Honor, but it was plain to the court that it wasn't raised below, and this court, in holding...
But again, in my view, it's very important if people, because if, just as you forfeited forfeiture, the defendant could forfeit your forfeiture of his forfeiture. And in Pittman, the defendant did not say the government has forfeited a forfeiture argument.
Then, next, I would point out that the waiver doctrine that my colleague is relying on comes out of the collateral review context. And there, the argument, Linder is a collateral review case, and there, the point is that if the government has a defense to a claim in a habeas petition, it must raise that defense in its answer. Otherwise, it is waived. Here, the context is very different. My friend does not explain why that doctrine should be taken from that collateral review context and applied to the direct appeal context.
No, this is basic claim presentation rules.
Sure.
As in, if you think someone is asking the court to do something that the court can't do because the other party didn't raise it at the right time or the right way, the proper time to raise that argument is when the person does the thing you think has been forfeited.
Judge Heitens, I'll try one more example, and then I want to move to the merits.
Correct.
The other one is, imagine that after a day of trial, a defendant stands up and says, you know what, I actually think that the testimony that came in today was irrelevant and unduly prejudicial.
Okay.
If the government were to say, well, we of course disagree with that, and the court would say, objection denied, the defendant cannot then come forward on appeal and say, well, even though I did not raise a contemporaneous and timely objection, because the government did not say it was untimely below, they cannot argue that it was untimely on appeal.
I agree with you that I think that's analogous to here, but I'm not remotely sure you're right about that.
Well, the reason why, Your Honor, at the end of the day, what we're trying to enforce is a timeliness requirement. And because it was not made in a timely manner, this objection below,
And
it
what
is
the government-
untimely under Rule 12c3.
I agree with you. Maybe assuming that we got to it, there is a question, at least, whether this is the kind of thing that had to be raised under Rule 12. So another way to think about this is the benefit of doing this, of the government raising this issue before the district court, is there could have been a dialogue before the district court about whether this was something that was in fact required by Rule 12c, but because the government didn't raise this before the district court had no reason to consider whether this was something that had to be the defendant does not agree this is something that had to be raised under Rule 12c, and the whole point of claim presentation rules is we could have had a conversation in front of the district court about whether this was something that had to be raised under Rule 12c.
Agreed, Your Honor, but Judge Heitens, I very much, as my friend on page 37 of his opening brief acknowledges, whether or not a document was required under regulation requires construing that regulation. That is a legal argument.
Agreed.
But I'd like to move on.
Sure.
And I want to provide one last thing. In the United States, this court has, in the past, although in unpublished dispositions, repeatedly said that it will not consider an untimely Rule 12b3 motion if it's being raised in a Rule 29 motion. There are several cases that say that. I'll just quote one to the court. It's United States against Irby, 246, Federal Appendix 228, 231. That's a 2007 disposition of this court. But, Your Honor, I respectfully disagree. If something is raised in an untimely manner, the onus is not on the government. It does not have to argue that before the district court, because at the end of the day, what it comes down to is what is a proper standard of review on appeal, and that is something that is best subject to this court's analysis. Moving to the merits, the question here is whether when a regulation has a requirement, and it can be complied with in a number of different ways, and a party chooses to comply with that requirement in one certain way, does that then become something required by the regulation?
So do you agree with the dichotomy that I gave your colleague on the other side? Essentially, the question presented on this issue is one of two things seems like it's true. Either, and I'm bracketing the application, I'm bracketing the affidavit because I think there's an argument that the affidavit is different, right? And that the choice is the following. What other documents are required beyond those necessary to establish things like residency? But on a topic like this, either there are no other required documents, or any document you submit is a required document, that those are the two choices.
I disagree with that, Your Honor.
Okay, please, why am I wrong?
So the reason why is, here's how I conceptualize the two positions. My colleague's position is that if there's a requirement that can be satisfied in more than one way, because there's an option, A or B, and it just has to be more than one way, and because no one particular option is the
No, but he's
strictly required one.
he's conceded the 3 of the following 6 documents example.
But that undermines his entire argument, Your Honor. That undermines it. It does not matter whether you can choose 3 of 6 or 1 of a million. The point is, if you have a choice between how you're going to comply with a requirement and you choose something to satisfy that requirement, under plain language, that becomes something that was required by the requirement.
Except, okay, let me give you the example of what I'll call the extraordinarily fastidious self-petitioner.
Sure.
This person, in the interest of making sure there is no possibility that they will be found to have submitted insufficient evidence, submits 1,000 documents.
Sure.
Document 1, standing alone, is more than sufficient under any conceivably reasonable definition of what the amount of evidence you need is required. But it turns out that document 999 has a materially false, so that person's guilty. Even though it was completely, in a colloquial sense, that document was completely unnecessary, because by the time we got to document 999, they were so far over what they would ever have needed. They didn't need, right, that no conceivable adjudicator or decision maker could have thought that 999 was the marginal document. That defendant is guilty.
So I would agree that is a much more difficult case.
But do you think that defendant is guilty or not guilty?
I believe that if he supplies that document in satisfaction of the requirement, it then is one that, it is then a required document. I believe that a better defense would be, well, was that material to the government's decision?
Because I'm going to win anyway.
Yeah,
You're going to win.
but because there were 999 other documents, was that false statement material? That's the better defense. However, I want to point out that in this case, we are not dealing with those facts. For counts 4 to 13, the fraudulent...
Yeah, but that's how statutory interpretation works all the time. You have ridiculous hypotheticals that illustrate what one interpretation might mean.
And I believe that the correct rule is the one set forth in the Second Circuit by Konstantikakos, in which the court said, although the law certainly afforded defendants a choice as to how they would satisfy the documentation requirement, once they made their choice, the documents accompanying the applications were quote-unquote required by the regulations for purposes of 1546. And I think I can give a common-sense hypothetical that proves that the government's position is correct on this and my friend's position is incorrect. Imagine that the University of Richmond has a general education requirement, and it says for any freshman to stay in good standing, they have to take a mathematics course, and any math course will do. They can take calculus, algebra, quantitative analysis. My friend's position is because no one particular course is required, there is actually no math course requirement. He makes that clear on page 12 of his reply brief, that there's no documentation requirement whatsoever, even though he just stood up here right now and conceded, yes, something is required.
Well, but can I ask you the hypo I asked him? In principle,
Yeah.
do you agree that, in fact, one of the government's witnesses testified at trial that a valid self-petitioner could, in principle, submit a lovingly detailed affidavit that explains in exhaustive detail why there is literally nothing else they can present. And again, I want to wall off the couple places where the regs specifically require more, but absent those other places, that would be a sufficient complete application?
First of all, I disagree with the premise. That was not the testimony. You can look at...
Okay, fine. Forget
Yeah.
the testimony. Do you agree that that could, under the statute and regulations, be a complete application?
I don't believe so.
Why not?
Because VAWA self-petitions are not granted for the asking. If you
I'm not asking, no. See, I think the other thing the government is arguing with respect is fatally confusing, is whether this petition is likely to be granted, which to me is different from the question of whether it would be rejected as incomplete or legally insufficient.
I believe, so
Like, so for example, if you filed a complaint in federal court and didn't have a proposed summons, we might bounce it on you and be like, you have to prepare a summons, you didn't prepare a summons, your filing is incomplete.
So the testimony that my friend is relying on is simply that a person can use one document for multiple eligibility requirements. But at the end of the day, Your Honor, they still need to actually prove that they're eligible.
Yeah, they might lose.
And if you look at the regulation, it constantly cites saying, you need to go out into the world and find us court records, medical records, affidavits from third parties.
And then what it says over and over and over again is outside of a limited number of narrow circumstances. You don't have to give us any specific thing.
yes. But still, whatever document is chosen, whether it's an affidavit or not, that becomes something required. If I can get back to the hypothetical, Your Honor. If a freshman were to take no math course whatsoever, and as a result be placed on academic probation, and they were to challenge that, saying, I'm sorry, there actually was no required math course because I was given an option on what to choose, that would be an unsuccessful argument. Now imagine that freshman were to then take a math course, he would choose calculus, and he gets a B in that class, he gets an A in everything else. But there's another rule that the university has. You may not get a non-A grade in any course required by the general education requirements and make the dean's list. If the student were to have taken calculus in fulfillment of the requirement and say, well, I should still make the dean's list because I wasn't strictly required to take calculus, I could have taken algebra again, I think that anyone using the plain language of required would say, no, I'm sorry, you got a non-A grade in a required course. It's the same thing here, Your Honor. And I want to point something out. My friend tries to make it seem as though there's something unique about VAWA self-petitions, but there isn't. Or let me put it this way. What is unique about VAWA self-petitions is usually when it comes to immigration petitions, the petitioner must provide primary evidence. If they cannot provide primary evidence of whatever it is, citizenship, relationship, bona fide marriage, they must show that primary evidence is unavailable, and then they may submit secondary evidence. What is special about a VAWA self-petition is that it's written into the regulation that from the get-go, the self-petitioner may file any credible relevant evidence showing that they are eligible. But the fact that there is more than one document that can be used to satisfy the regulation is common throughout the immigration regulations. The government cited, for example, 8 CFR 204.1G1. That is the I-130 application, which is what abused aliens had to use before VAWA self-petitions were created. And there the petitioner has to prove their U.S. citizenship. And the regulation says you must submit one of the following. And it provides a list of things. You can provide a birth certificate. You can provide an unexpired passport. Again, my friend's position is that because there's no one particular document that must be filed, those are not
Well, actually,
required
I think
documents.
that's, as I understood his argument earlier today, that is in fact the opposite of his position.
Well, his position is then fatally inconsistent because the second he says that that if you have an option in what you can choose and what you choose then becomes a required document.
He's saying, but if you have an option and it must be one of the following, he's saying, in that situation, the one that you choose is. But it's against the backdrop that there's a list that says you must. And if you don't, your application is fatally deficient. You include one of like 1, 2, 3. Whereas this doesn't say that. It doesn't say you must include one of, well, anything.
Then point the court to Constantakakos, the Second Circuit decision. There it was the petitioners had to file one of 3 different types of evidence. Not specifically named documents, but different types of evidence. And they said, well, because the photographs we submitted was not necessarily what had to be submitted to satisfy that type, it wasn't required. But the Second Circuit rejected that argument. And I very much believe that the second, my friend acknowledges, as he must, that when you're given a series of options on what to choose and you choose one that's required, that is fatal to his argument. One last thing. Here, You're
good. I did not cut your colleague off. I'm not going to cut you off.
The regulations provide for any credible evidence. In theory, if you wanted to, Your Honor, you could create an expansive list of all the relevant credible evidence in the universe. If you're going to say...
Sure, if the regs were written that way.
Yeah, but one could, just imagine the infinite library. One of anything on that. If my friend's argument, as it seems to be understood, is that, well, then anything chosen off of that list is a required document, that, again, is fatal. What we're looking...
But why is that fatal? I mean, I guess you might say, you might say that those regulations aren't meaningfully different and there's no significant difference, and then people say, criminal liability is a really big deal.
It's because it comes down to the plain language of required by. I want to make something clear. My friend cites no case that supports his position. This is why. Ryan Webster Jimenez both say something that the government agrees with. If the regulation says you must submit one particular form, yes, that is required. The question, though, here is more nuanced. If it says here's a requirement, but you may do multiple things to comply with it, Is the one you've chosen required? I would say yes. One other example, Your Honor. We both agree that Black's Law Dictionary sets forth the plain meaning of required. Black's Law Dictionary, when it says, Black's Law Dictionary, in its definition, gives us the example of something that must be done because of a law or rule, building requirements specified in the Americans with Disabilities Act. We pointed to Tennessee against Lane, in which the U.S. Supreme Court said that Title II of the ADA provides for accessibility requirements for buildings. And then it says those requirements may be satisfied through, quote unquote, a number of ways. So you can either build a wheelchair ramp or build a lift to make the building accessible to the handicapped. My friend's position, again, is because there's no one thing that is required, there is no accessibility modification requirement. Of course, that's not the case. My friend's position is next.
Unless my colleagues have any question, I'm going to ask you to move to issue 2.
Sure. Moving to issue 2, I think this is one that is clearly waived. And I say waived for this reason. There's a reason that you pointed out, Judge Heitens, that it was forfeited below because they didn't renew the Rule 29A argument. I would note that there is no forfeiture exception to preservation, although my friend cites a fifth.
Well, and also I've also struggled to think about, the difference here, it strikes me, is when is the first time the government could realistically have brought this up? It strikes me there, it's your bottom side brief. Like, if he didn't renew his Rule 29 motion, I don't know when you're supposed to point that out except in your bottom side brief on appeal.
I simply want to point out, Your Honor, my friend relies upon a Fifth Circuit case from the 1990s, Pennington, and then a Ninth Circuit case from the 2000s, Esquivel, to argue that there's a forfeiture exception to preserving a legal issue. In 2021, the U.S. Supreme Court in Greer against the United States, that's 593 U.S. 503, rejected the idea that there is a futility exception to preservation and a futility exception to plain error.
I think they said that a whole bunch of times before,
Yes.
Greer.
And so as a result, this is unpreserved, and my friend doesn't have a serious plain error argument in his reply brief. He goes through all 4 prongs in 4 sentences with a single CF cite at the end.
Oh, so just so I understand, the argument is there's no, okay, so you can't get out of plain error review by saying it would have been futile to object, so you can't get out of failure to renew Rule 29 on the ground. It would be futile to renew Rule 29.
And he doesn't show plain error. I'd also honestly say that his futility argument should be waived. It's raised for the first time in his reply brief, even though it's an integral part for why he thinks he should get de novo review on a plainly forfeited thing. And the final one, the United States against Ely. Even if this court were to agree, even if it were to agree with the defendant that there was insufficient proof of direct liability, the jury was also instructed on aiding and abetting and Pinkerton liability. For the defendant to argue that the district court erred in rejecting his Rule 29 argument, he would have to show that there was also insufficient proof under those 2 other modes of liability. This court in Ely, 2004, a published decision, said that when a defendant challenges only one theory of liability but doesn't challenge the other ones, it is irrelevant to his challenge and it will affirm on that ground alone. My friend says the onus was on the government to prove that the evidence was sufficient under the other modes of liability. Wrong. It is always on the appellant to show is insufficient, and there was proof, by the way, for the jury to find that someone else submitted the forms. It's the forms themselves. If you look at the I-360 petitions, they're all signed under Part 11. Part 11 is to be signed only when it is the self-petitioner, him or herself, who is filing the petition with the government. So that is a sufficient ground to find that someone else, under penalty of perjury, signed the petitions and filed them. On the merits, Your Honor, there is the defendant's argument. He tries to use a series qualifier canon, Your Honor. It simply doesn't work. The series qualifier canon is once you get a modifying phrase, whether it's an adjective or an adverb, and it comes at the beginning or an end of a series, you can think that it applies to the entire series. Here, the statute is written where you have verb, adverb, and then another verb, and he wants to say that it applies to any such false statement. Basic rules of grammar say that doesn't work. We cite Sutherland's statutory construction. There it makes it clear that when you use the word such, it refers to the antecedent noun and any adjective modifying that noun. My friend wants to extend that to an adverb modifying the verb in the prior clause. He doesn't argue for why that would even work. No court has said it would work. Asherov is the one case he has to rely on where the Third Circuit found that the statute is grievously ambiguous, but the Third Circuit only did so because it believed that it had to view the person who knowingly makes the false statement as being the same person who knowingly presents it. But as Your Honor, I believe...
I mean, in fairness, the Third Circuit was presented by a situation in which the government seemed to be trying to engage in some cute little efforts. Like, the government was violating the classic don't get cute rule in that case.
Whereas here, and I mean, this goes back to Justice Breyer's concurrence in Alvarez, where he makes it clear the law generally does not hold someone criminally liable for lying unless that lie were made under oath. Because by making the lie under oath, it is brought to the attention of the person the seriousness of what they're doing, or under penalty of perjury, the consequences that might follow. But the law regularly criminalizes someone who knowingly presents a false statement to the government because they're on notice of the harm that might occur. Here,
And just so I understand the government's interpretation of the statute, your view under the presents clause for the defendant, it is not sufficient that he presented an application that that included a document that had a statement that was in fact false and that was in fact material. In addition, he has to know that the document he presented has a statement that's false, right? There's no like, I innocently turn in a document that happens to contain a false statement.
It's a knowing presentation.
And when then, as a person who argued and lost a case about mens rea in the Supreme Court, that involved a similar issue. So in other words, if he knowingly presents the piece of paper, as in he knows he's presenting the piece of paper and he knows who he's giving it to, but he does not know that something in the piece of paper is false, he is not guilty, right?
Yes.
Okay.
But I want to return quickly, while I can, to the merits of the required by challenge, because this truly is significant. There is no principled way, I believe, for the court to write a decision, or it would be difficult to say that if a regulation provides one of several ways to fulfill a requirement, including open-ended ones. So if you look at Constantakakos, if you look at 204.1 G1, throughout the immigration regulations, it says, you know, when it comes to secondary evidence of citizenship, it says secondary evidence includes but is not limited to, and then it's an open-ended thing. Really, whatever credible evidence is out there to prove that you, petitioner, are a citizen. Under my friend's rule, the strict reading of it, and he shifted it here at oral argument, his strict reading, if you look back at his brief, is that if there's no one particular document that is required, no document is required. That is not how plain language of required by works. So once my friend here recognized that he needed to shift ground and concede that when a person picks a certain document off of a list, that becomes required by, I think it then follows that once he picks something off of the expansive list of any credible evidence, it's also one that is required by. And to your position, Judge Heitens, I believe that if it is done in satisfaction of the requirement, it is indeed one that is required by. And I want to reiterate one last time, my friend has come forward with no authority. Ryan Webster and Jimenez both stand for the very, it simply says, if something must have been filed, it is
Okay, so you said that a couple times now. Oh, I said this a couple times now. You said he's got no authority that squarely says he's right. What's your best authority for the view that you're right? Do you have a case that involves this situation that says you're right?
Yes, I would say that Constantakakos and Wu are two examples.
Okay, those are your.
And I would actually ask you to look at the regulation itself at issue in Constantakakos, because it doesn't say you must provide the 3 of these 6 specific documents. It says here are 6 types of evidence you can provide. You need to provide anything within those 3 types of evidence.
Great.
And finally, one last thing. I just asked to run through plain language examples, to return one last time, if I may, and then I'll finish up, or I will be finished, in the plain language space. If a state were to, given the open-ended accessibility requirements under the ADA, if a state were to modify, if they were to create a wheelchair ramp so that an elevated platform is accessible to the handicapped, under my friend's position, if a building inspector were to come and ask, could you please show me the
Okay, I think we've done the
modifications you made that
ADA.
required?
We've done the ADA example. If you have a new one, please feel free to give it to us.
Sure. If you were to go to the DMV and they were to say, we require proof of residence, and we'll leave it to you to determine how are you going to prove your residence within the state. If a person were to show up with no documentation and they were to say, well, I'm sorry, you didn't specify what I had to bring, so there's no documentary requirement, they wouldn't get their license. If they brought a lease agreement and they were asked, do you have your required proof of documentation? The person would say, no, I don't, but I have this optional proof of documentation. I think anyone listening to that conversation would think that person doesn't understand the plain meaning of required by.
Great.
Your Honor,
I'm going to ask my colleagues if they have.
Just one quick question, so is, of course.
And there's a
I
Rogers
think-
error, by the way.
And this is probably just so I'm clear as to the
Yes.
government's position, because Judge Heitens asked something similar to it, I think regarding the witness testimony. So is the government's position that you have to have more than just the application?
Yes, absolutely, you have to have more than just the application, and you can see that 8 CFR section 103.2B1 says that all petitioners have to show that they are eligible for the relief that they are seeking. B8 makes it clear that you do so through supporting documentation and evidence. And if you then go to 204.2C1, it sets forth the basic eligibility requirements. C2 sets forth the evidence that is required. My friend says, well, because it says this evidence may be submitted and the evidence may include these things, proving eligibility is optional, but that is wrong. And you can see that again in 103.2B1. You may not get your petition granted if you do not show your eligibility.
All right, thank you very much.
Thank you very much.
Mr. Block, you have some rebuttal time?
May I proceed?
Mm-hmm.
Thank you, Your Honor. I'll try and run through these briefly. First, the government has represented that VAWA self-petitions are not unique amongst immigration forms, and that's simply inconsistent with the record. And I just want to cite, again, JA 1676. That's Officer Arnell, who was called as an expert in the immigration laws. And she testified that, quote, the very purpose of VAWA and the people that it's designed to encompass, that makes it that there's no specific per se document requirement. So I think the trial evidence was quite clear, Your Honors, that the VAWA self-petitions are unique. I do want to briefly touch Pinkerton because the government raised it in its argument. The government's argument is not that aiding and abetting or Pinkerton liability actually apply here. All it's raised is a waiver argument, essentially that if in your opening appellant brief you do not address all different forms of liability, that you then waive any argument against, you waive any argument that the district court erred in denying your Rule 29 motion. And that's not supported by the cases that the government cites. Specifically, the government cites Stevens on page 36. That's a case about whether or not Hobbs Act robbery, if proven under an aiding and abetting or Pinkerton theory, is a predicate crime for 924C. And then they cite Katakis and Ile, both of which just spout this general principle that as an ordinary matter, where the government alleges that multiple theories of liability apply, if you only challenge one theory of liability, then your challenge is waived. That's not the case we have here, again, because the government has not actually argued that Pinkerton or aiding and abetting liability.
Well, but hold on. The jury was instructed on both of them, right?
They were, Your Honor.
And the argument you're making is the evidence was sufficiency of the evidence, right?
That's correct.
And I know, it's not immediately coming to mind, but I know for certain there's a whole series of Supreme Court decisions that say if the indictment charges two theories of liability, the evidence is legally sufficient on one theory but legally insufficient on the other, and the jury convicts, defendant loses because we presume that the jury in that situation returned a guilty verdict on the theory for which the evidence is sufficient, right? That's true, right?
That is certainly correct, Your Honor, and we're not challenging that, but we are.
So in other words, you are not challenging that the evidence was legally sufficient on a Pinkerton theory or an aiding and abetting theory because you've made no argument to us that it wasn't.
So to be clear, Your Honor, in our reply brief, we did explain briefly why Pinkerton and aiding and abetting liability have no application to this case. Our argument is simply that there's no case saying that there's this waiver doctrine created from this rule, that if you do not, in your opening blue brief, address all theories of liability.
But you do, I guess, so whether the waiver issue is a separate issue, but you agree that in order to win, it would not simply be enough that the evidence is insufficient on a primary actor theory. For you to win this appeal, the evidence would in fact have to be legally insufficient on a Pinkerton and aiding and abetting theory.
That's correct, Your Honor. And certainly if this court is quite concerned, if this court is concerned about Pinkerton or aiding and abetting liability, we're happy to file a supplemental brief on this.
I think the government's argument is that's what your opening brief's for.
But the government's only argument is waiver, not that those theories actually apply. Unless there are any other questions on that, I want to move on to the required documents prong. So the government suggests we've shifted our argument at oral argument. That's just not true. Our argument has always been that for a VAWA self-petition, there are no required documents. We acknowledge, though, in interpreting 1546 that in other statutes and in other contexts, where a regulation specifies, for example, in the Second Circuit case the government cites, you must submit 3 of the 6 following documents. We agree that those documents are themselves required. And the government has simply not grappled that argument or in its briefs with the fact that its reading of the law, which is that if a doc is filed in support of an eligibility requirement, it is required. It
But
reads out.
is it true that you could submit an application without a single document and have your petition granted?
No, Your Honor. You do
So
need.
you are required to submit something.
You do need to submit something in addition to the Form I-360, but there's no specific
So you're
document.
required to submit something, so once you submit something, I think it's fair to say it's required.
We would disagree, Your Honor. We
Not
think
that specific document, but that something is required.
something is required, Your Honor, and that goes to its materiality. It is material because you need to provide some evidence related to the eligibility requirements, but the government's reading of the statute eliminates the required documents prong. Essentially, under the government's reading, if you file a material application, it is in a required document no matter what. But again, those 2 independent elements of the statute have to be given independent meaning.
So you're suggesting the word material modifies all the way to all of the examples, doesn't just modify the word fact?
Well, Your Honor, under the government's reading, any time that you present a material falsehood, it is necessarily in a required document. And we don't think that's the proper way to read the statute. There are 2 separate elements that the government needs to prove. One is that the falsehood was material. That is, does it relate to an eligibility requirement? And the second is it in a document required by the immigration laws? And surely USCIS knows how to require documents. I mean, if you look at a sister regulation, 2.
Right, but it did, there's something smart in VAWA that it's not any one particular document because necessarily an applicant might not have access to her birth certificate or some other document because her abuser might be maintaining it and not giving it to her. But she cannot prevail without anything, so something is required.
Well, I think, again, Your Honor, we agree something needs to be filed in order to meet the eligibility requirements. But again, if you look to a sister regulation, 204.2b2, that relates to a widower application, which is also filed on the Form I-360, there the regulations are clear. You shall submit a marriage certificate and you shall submit a death certificate. And I see my time has expired. May I just finish this thought?
Absolutely.
That is an instance in which the regulations require those particular documents. And that's quite different in this case where the regulations say you are encouraged to submit primary evidence. You may submit a lease agreement. I mean, that is a material
But
difference.
I think if you look at the construction of the regulations, and say, the may is to give flexibility to the VAWA victim as to what they can present. So I think in follow-up to Judge Berner, so you're not tied to, oh, you have to present this, you must present this. And that's the may, and it seems as if that is what the intent was, to give the flexibility to the applicant to provide different, but it's not saying that you cannot provide anything.
We agree, Your Honor. I mean, you must submit a document in addition to the Form I-360. But the question here is whether Congress, which has limited the criminal liability 1546 imposes only to material falsehoods in required documents, whether or not optional documents affixed to the Form I-360 can expose someone to criminal liability. And I think Judge Hyten's example was important there. If you file a self-affidavit in this case that completely covers all of your eligibility requirements, but you then file a false lease agreement, I know the government says that the best defense is materiality, but the government's position is still that that lease agreement is required under the immigration laws, even though it's plainly not, because the self-affidavit did, reached all of the eligibility requirements you need. Unless this panel has any other questions.
Thank you very much, Mr. Block. I see here that you are pro bono counsel in this case.
Yes, Your Honor.
I'd like to thank you on behalf of the entire court. We rely on people who volunteer their time and their efforts and their resources to do these, and we very much appreciate it.
Thank you.
We will come down and greet counsel and then proceed to our last case of the morning. No longer morning.
No.
1742 A&N Electrical Cooperative versus Dietzel. Am I saying that right?
Yes, Your Honor.
Dietzel Enterprises Incorporated. It looks to me like Mr. Wright is up first.
Yes, good afternoon, Your Honor.
Proceed whenever you're ready.
Thank you, Your Honor. Good afternoon. May it please the court. Gibson Wright and McCandlish Holton here in Richmond for A&N Electric Cooperative. This matter involves A&N's claim for indemnity for a wrongful death claim under 59.1-414B of the Virginia Overhead High Voltage Line Safety Act, an important prong of the Act's enforcement provisions.
Mr. Wright, before, it's just been so distracting to me when I've been reading all of the documents in this case. Can you please tell me, this is literally to satisfy my curiosity, what happened to MRA and the underlying suit? Like, no one tells me what happened, I'm literally curious, and until I know that, it's going to be very hard for me to focus on anything else.
So they got a defense verdict.
Okay.
And we settled right before after we did jury instructions and then before closing argument.
Thank you.
And as pled, we're at 12B6 posture. As pled, the settlement was reasonable in light of the verdict we faced and legal rulings that had gone up to that point.
So is the only issue now basically dueling insurance policies and who ultimately pays?
So it's not an insurance policy. I think that's very important, actually, because this is a statutory claim. This is under the Virginia Overhead High Voltage Line Safety Act's indemnity provision, which says that the person responsible for the work, which is Dietzel and Allstate, Dietzel being the employer of Mr. Fink, who was unfortunately electrocuted and died, and then Allstate being the general contractor on the job working on the communications tower. They didn't follow the provisions of the OHVLSA in this case.
I understand, but the decedent's estate has already been paid.
Yes.
The question is, who's responsible for that
Yes.
payment?
And our position is that that claim that we paid under the Act, the person responsible for the work that doesn't follow the OHVLSA, that violates 59.1-408, which is the working within 10 feet without giving notice and then following the provisions of the OHVLSA, has to pay that claim.
And this is purely a question of Virginia statutory construction, is that right?
Yes.
And it's a question that's never been reached by a Virginia court?
Yes.
So we have no Virginia precedent to follow?
Yes.
So my question is, why wouldn't we then just simply certify this question to the Virginia Supreme Court and have them tell us what their statute says?
I mean, if the court's inclined to do that, I think that is at the court's discretion. I mean, I obviously think it's clear for us, but if the court's inclined to do that, I don't really. I will say that there's no case on point under Virginia law. We are the only people.
But who's the reason that we're in, sorry, this is a question I often want to know in diversity cases. So this is a question of Virginia state law. The Virginia courts could have just answered this question. It's your client
Yes.
who chose federal court, right?
Yes.
They didn't drag you into federal court.
No, we sued under.
So you picked federal court, you lost, and now you're telling us that the district court got Virginia law wrong.
Yes.
Okay.
So, and I mean, there are reasons for suing in federal court in terms of quickness of decision. I mean, there was, not to get in too far, but there are a lot of rulings and non-rulings in the state court action which led to.
Oh, I used to practice in Virginia state court. I'm aware of some of the challenges of doing that.
So, yes, and so this went all the way to jury, as often happens in state court, and so we think it's a pretty distinct issue under the OHVLSA, and it's an important part of the OHVLSA that when you, as a person responsible for the work, don't follow it, you've got to pay the consequences. And the Act enforces that on the front end and the back end, and we were seeking to seeking to recover under that, and that's why we filed in federal court. We thought I'd get a quick answer on it. And the answer that the court gave us was that the exemption under 59.1-413 applied, and it does not. And I think I'm sorry, Judge Berner, I mean, if the court's inclined to certify this to the Supreme Court of Virginia, then, I mean, that's the court's prerogative. I don't really have a position on that, other than I think that, as for the reasons we've stated in the briefs, it's clear that the exemption, the district court got it wrong in interpreting the exemption over broadly. And if I could explain that.
It just seems to me that reasonable minds can clearly differ. If a very smart district court judge got it one way and you think it goes another way, then it's reasonable minds, I suppose, could look at it differently.
Yes.
And here, this is a fairly unique situation where we have an issue of state law never before resolved. The question answered would resolve the entire case, and we wouldn't be wading into construction of statutes of the states.
I'd agree, Your Honor, and I also further state, this goes to my argument when I later talk about the alternate grounds that the court could affirm if it decided not to certify this question. There are certainly other states that have ruled upon similar OHVLSA type acts. I mean, this is a
Is this like a UCC type, or like, why do all states have these statutes that all address the same thing in remarkably similar language? Where do these statutes come from?
Well, because working near overhead voltage lines is dangerous.
Oh, no, I understand why, but it seems, it's striking when you see a whole bunch of states have laws that are written very similarly. It makes me think that they might have a common source.
Well,
like the UCC. I mean, I know this isn't the UCC, but like the UCC.
well, I know that there's an interplay between OSHA regulations and the OHVLSA in terms of the 10-foot rule. And of course, you've got people like Dietzel who are from Nebraska coming to Accomack in the Eastern Shore of Virginia. You know, these are certain basic rules of construction. When you have a project and you're working your overhead high voltage lines, I think there's a benefit for states adopting similar rules. I mean, I would say there's a policy inclination that the legislature has shown in enacting these statutes that they want to protect people and overhead high voltage line operators and owners from incidental contact with lines and subsequent claims. So I think that's why a lot of different jurisdictions have adopted this act. But to the point I was going to make in terms of other jurisdictions, I couldn't find a case in other jurisdiction addressing the specific issue of an exemption like this. So, and the exemption language does differ a little bit in other states, but there's the case law that we've cited in other jurisdictions is much more on point for the workers' compensation exclusivity provision.
What about the Maine statute and the case out of Maine? The Central Maine Power Company case?
Yes. So the exemption was not at issue in that case. So I think that the point in that case, in terms of, and this is jumping to the, I think the general theme that this is a claim for equitable indemnity because there's not a contract, and therefore you've got to be found liable first, and otherwise it's totally essentially unfair that we're holding the bag for this. And I think the Central Maine Power Company case involved somebody working on a sailboat, and the mast of the boat hit a line. It was allegedly lower than it should have been, so there was some you could have knocked the power company in that situation. And there was a suit where the power company sued for indemnity, and the indemnity statute in Maine allowed for indemnity for all claims. And the Maine Supreme Court said, look, it says all claims, and we're reading this, you've got to pay for all claims. It doesn't matter if the power company was allegedly partly at fault. And in fact, they raised a Maine comparative negligence statute talking about, and they said, no, look, this statute is clear that the person responsible for the work, when they violate the provisions of the OHVLSA, they've got to pay for all that. And there's an important policy provision behind that, which I do want to emphasize to the court. That this is what the court said in the Central Maine Power Company case. It said the entirety of the statutory scheme comprising the Act, which is Maine's version of the OHVLSA, places a particular burden on employers of individuals who work near overhead high voltage lines to comply with the Act's provisions or face penalties. And it goes on to say, because the potential for grave and even fatal injury is high when employees work near power lines, The legislator's enactment serves to motivate employers arranging for on-site work to make every required measure to avoid injury. So that's what we've got here on the front end and on the back end. Unfortunately, none of the OHVLSA was followed here. As pled, A&N never got notice, which of course triggers a process by which the person responsible for the work talks to the owner or operator of the line, A&N, to figure out temporary safety arrangements that then they can agree, and the person responsible for the work has to ensure those temporary safety arrangements are in place before they even work. And then, if subsequently somebody's injured, if they don't, so that act is on the front end requires people to follow the OHVLSA. On the back end, if you don't do that, you're going to get sued for everything. And there's nothing unfair about that. It's important. The legislator wants to encourage people responsible for the work to notify power companies and then to go through this process. And of course, people responsible for the work are the people who are going to know whether or not somebody's working near the lines.
So this probably piggybacks on Judge Berner's point that maybe this statute's at minimum really ambiguous, because can I take you to the indemnification point?
Yes.
Does the statute require settlement to be reasonable to get indemnification? It feels like this feels like a yes or no question. Do you think this statute? No.
I say it says all claims, and I think it's a belt. I think to their point, they have a point where they say, well, how can you require us to indemnify for a claim that you shouldn't be liable for because of 59.1?
But does that really seem right? Do you imagine that the other party could make a deliberately ridiculous hypothetical, a party that has a 100% valid merits defense settles for $1 billion. You really think they can get indemnification for that?
So, Your Honor, I pled in the complaint that...
I know that's not your case. I'm asking you, though, but do you think the statute would say that the party who settles a frivolous claim for $1 billion could get indemnification?
I think if you read in contractual indemnification law in terms of where you've got somebody that's contractually obligated to indemnify somebody else, if they make a payment that is unreasonable, I think there's certain case law that if you tender the defense and they refuse to participate, you've got certain additional protections. That's some stuff in the record that wasn't really, that's kind of not really here yet. Sure. In terms of, we broadly pled that we told Allstate and Dietzel, you're going to be on the hook for this.
I'm still not really sure what your answer to my question is.
So I think it'd be really dependent. You can't, I think my answer to your question is you can't 100% just voluntarily pay something, and I'm using that, this is different than the voluntary payment doctrine, which deals with an equitable thing outside of contractual indemnity. But you can't just voluntarily give it up without any sort of reason. We've pled here, though, that it was a reasonable settlement.
And you would propose, now, again, the Virginia Supreme Court can say this statute means anything in the world the Virginia Supreme Court wants to say, but you would have us say that that limitation is where in the statute?
So I think...
Like what statutory language imposes that limitation?
It says all claims, so I don't know necessarily if it's there, and I think I would tell the court that the reason it's not there is the statute's more concerned on the front end and back end, making sure that people comply with the OHVLSA. And I think there's also a component too of protecting power companies. If they have no idea somebody's working near a power line, person responsible for the work have to notify them and they have to go through this process. So when you don't do that, you've got to just play the claim. And I think too, it's a part, claim, which I think is a different word than they use in the main case. It's not a liability. It's not taken to judgment. It's any claim resulting from work that's in violation of the act. And I think they're saying all claims just because they want to make so clear that you've got to follow it, and when you don't, you're totally on the hook. And I think that's a totally legitimate policy reason for the state to do that. I guess, brief points on the statutory interpretation point were the court to decide it and not send it to the Supreme Court. So the district court below essentially said that in the exemption says this. It says the act doesn't apply to overhead electrical or communication circuits or conductors and their supporting structures and associated equipment of those conductors or circuits of 4 different things. And it lists 4 different subsets, including rail transportation systems, electrical generating systems, communication systems, or any other publicly or privately owned system. What the district court did is it said that it was going to refuse to read it narrowly and not read or, they were going to read or in disjunctive, and essentially read this thing backwards and forwards and say, because or is in there, if you're ever working on a communication system, a rail transportation system, or any other public system, as long as you're the owner, this doesn't apply. And that, I mean, that exception swallows the rule, and it doesn't make sense. I think you're putting so much emphasis on or that you're forgetting you're totally writing out the word of. This is talking about communication circuits or conductors of certain things. And of course, you'd have surplusage if you're saying that the tower was a communication circuit. You'd have, without a court's reading, you'd be saying a communication circuit of a communication system. That's two things of the same thing. That doesn't make sense. And of course, we can't, so if I finish this thought.
Absolutely.
So, you know, the broader point here, this statute is all about overhead high voltage line safety. And in order to exempt, it's got to apply in the first place. You can't be an exemption without exempting. And so this whole thing is talking about when you're working with lines, you know, you've got to be working with lines to which the other act apply. To me, the clearest reading of this, which makes the most sense, is they're talking about overhead lines, circuits, or conductors, which the act defines a line to be a circuit, that are up in the air, that are part of some system that the owner is working on, that otherwise the act would apply to. If you've got it says railroad system. If you have a railroad that's running an electric cable, if you're working on the cable, that's probably an overhead high voltage line, but that's part of that system. That doesn't apply. The line he hit here had nothing to do with what he was working on.
Or at least as pled in the complaint, the line he hit here had nothing to do.
It's pled in the complaint, absolutely.
Sure.
Yeah, it wasn't serving it, it wasn't of it, it was incidental contact. He bumped into it while working on something else. That's precisely what the OHVLSA is supposed to protect against.
Great.
Thank you, Your Honor.
Thank you, Mr. Wright. I understand the appellees are splitting their time and that I believe Ms. Palmer is going first, or are we?
Actually, Mr. Hoyle was going to go first.
I'm sorry, my mistake. Please go ahead.
Good afternoon, and may it please the court. My name is Lee Hoyle on behalf of Appellee Dietzel. I will be speaking for 8 minutes on the exemption of Section 413, as well as the viability of a claim for indemnity under Section 414, where the estate had no claim against Dietzel due to the operation of Virginia's Workers' Compensation Fund.
Can you address, before we begin, our question about certification to the Virginia Supreme Court?
Your Honor, I don't believe that certification is necessary in this case under the exemption, because the exemption is clear, in our view, that the work going on was in fact exempt and under the plain language of the statute, and therefore certification is unnecessary because the Virginia Supreme Court and this court have said you consult dictionary definitions to determine the plain and ordinary meaning, which is what the district court did, and under that plain and ordinary meaning, the work was exempt. This court should affirm the judgment of dismissal based on the exemption in Section 413 for the simple reason that the phrase electrical or communications conductors or circuits or conductors includes far more equipment, far more materials than electrical or communications lines, as my colleague has proposed. The Overhead High Voltage Line Safety Act applies not to work on lines, but to any work in the vicinity of lines. And then the legislature has determined to take that broad structure and exempt from it work, specific types of work, the construction, reconstruction, operation, and maintenance of 4 types of, among other things, communications conductors and their supporting structures and their associated equipment. The words, and I focus on the words communication conductors because I think it's the very clearest application of the exemption in this case. And those 2 words are not defined by the statute, so the district court did what the Supreme Court of Virginia and this court have said it should, and consulted a general purpose dictionary, a dictionary that the Supreme Court of Virginia has used as recently as 2 years ago, and said, and read what the definitions of communication and conductor. Under those definitions, a communications conductor, at a minimum, includes any object or material that is capable of transmitting information or energy. In this case, the tower that was being worked on at the time certainly meets that definition. It is part of a communication system. It broadcasts radio waves, which is a form of information or energy. So it's either itself a communications conductor, Or, at a minimum, it is a supporting structure of a communications conductor or its associated equipment. Now, whether it's a conductor, structure, or equipment is irrelevant because the exemption applies to all three. Under the plain language of the statute, the exemption applies.
Doesn't that make this exemption extremely broad, essentially swallowing up the whole rule?
No, Your Honor, because the statutory structure as a whole applies to all work in the vicinity of overhead voltage power lines. The exemption then applies to very specific types of equipment owned by the owner of the system itself. You have the requirement that it be an electrical or communications conductor or circuit. So it's a specific type of those two types of equipment. And the work must be part of a system, one of 4 types of systems, and the work must be done on behalf of the owner of the system. So it is very focused on exempting work done by the owners, either by or on behalf of the owners of electrical or communication systems. And that limitation makes sense because the owners of these types of systems may very well have a significant amount of equipment that is, quote unquote, in the vicinity of overhead high voltage safety lines. And the legislature would have good reason to want to make sure that the owners of these types of systems are able to operate their systems. They're able to maintain their systems, to be able to go into areas that may otherwise fall within the very broad definitions of the OHVLSA without having to provide notice to the operator, without having to negotiate with the operator, without having to come up with a remediation plan and then subject to certain exemptions, pay for it. You're imposing costs and delays on the owners of, or people who want to do work. And the legislature has decided we want the owners of these specific types of systems who may have a significant portion of their operations near overhead high voltage safety lines, we want them to be exempt to make sure that they're able to do their work without unnecessary costs and delays. And that gets to a fundamental problem with A&M's argument. A&M's argument comes down to we believe that this should have been covered because we believe this accident should have been prevented, but that's a policy judgment. That is a policy judgment that the exemption shouldn't apply because a bad thing happened and we don't agree with where the Virginia legislature drew the lines. The Constitution doesn't vest this court with the prerogative to make that policy judgment. It is for the Virginia legislature. And the legislature spoke clearly when it exempted work, this type of work on this type of system.
So the part of the exception you're relying on is the language that says communication conductors. So you're saying this radio tower line is a communication conductor, is that right?
Yes, I believe that the district court was correct when it ruled that it was a communication conductor. I also.
That may all be true, but doesn't the statute, why doesn't overbroad modify everything that follows it? And why isn't, at least based on the allegations here, that he wasn't working on overbroad, that argument basically?
Because the OHVLSA does not require that he be working on a line of any sort. It requires that he be working in the vicinity of. So you could be doing any sort of work. You can be doing painting work, tree trimming work, construction work. You can just, any sort of activity that brings a person or a piece of equipment in the vicinity of an overhead high voltage power line is within the scope of the act itself. It is specific types of work on specific types of facilities that is subject to the exemption. And the exemption applies only to work on communications, conductors, or circuits, or electrical, done by or on behalf of the owner of that sort of system. And that's why it's not overbroad, because you get types of systems and the specific owners who are subject to the exemption. So you don't have tree trimmers going out who, you don't have any sort of work that could potentially involve a communication system isn't necessarily exempt, because if it's not done by or on behalf of the owner of the system, which we have here in the form of the county. The proffered definition I state in my brief violates multiple canons of statutory construction, including the simple fact that the Virginia legislature chose to use the word line 12 times in the statute, but then chose not to use the word line in the exemption. It used the broader term circuits or conductors. implying that it didn't mean to limit the exemption to lines, and in fact, interpreting both these two words to mean lines would render one or both of them to be meaningless. And I see my time has expired.
Thank you very much. So we will now hear from Ms. Palmer.
Good afternoon. May it please the court, I'm Julie Palmer, and I represent the appellee Allstate Tower Incorporated. We certainly adopt Dietzel's arguments with regard to the district court's interpretation, correct interpretation of the exemption found in 59.1-413. But should this court disagree with the district court, there is an equally legitimate alternate ground upon which this court should affirm the court's dismissal of A&N's claim for indemnity. And that is because the facts pled by A&N do not state a plausible claim for indemnity under Virginia law. Virginia law recognizes two types of indemnification. One is contractual, which all the parties concede there was no contract between either Allstate or Dietzel and A&N providing for indemnification. The other option then under Virginia law is equitable indemnification.
Wait, but, okay, so this maybe is just another argument in favor of Judge Berner's certification suggestion. How do I know that that doctrine applies to a statute that by its own terms provides for indemnification?
Well, there are multiple reasons within the language of the statute and within well-recognized statutory construction principles which lead to that conclusion. But first, one would be the absence of any recognition in any other statute or case law that the parties have been able to find of any such thing.
All you're really doing now is convincing me this statute is potentially quite ambiguous and uncertain indeed.
Well, let me turn to the language of the statute itself then, Your Honor. Under the rules of statutory construction, courts presume that the legislature knows and has in mind the common law in its enactment of the statute. So quite to the contrary, A&N argued that essentially this statute creates a contract between the parties. That is not the case, and there is no principle of
It doesn't create a contract. I'm just looking at 59.1414B. Any person, that sounds like any person, responsible for the work who violates this statute shall indemnify. It doesn't say any person who would otherwise be required to indemnify under principles of equitable indemnification. It says any person who does X shall indemnify.
Correct, Your Honor. It provides for a right of indemnification.
No, it doesn't say right of indemnification. It creates a duty of indemnification. It says that you must do this.
But along the principle of construction that the legislature is presumed to know and have in mind the common law, the vehicle for obtaining that indemnification is through the concept of common law indemnification, which again is the only other recognized
And maybe
form.
the Virginia Supreme Court would say that. I mean, maybe, but that isn't what the statute says, right?
Well, I believe it does say that because because the statute does specifically reference common law principles. In 414C, the statute states, except as in A, so not as except as in B, but except as in A, nothing in this chapter shall be construed or applied so as to alter the duty or degree of care applicable to owners or operators of overhead high voltage lines with respect to damage to property, personal injury, or death. And with that language then, the legislature, as is always the case, is bringing the common law, unless it explicitly...
But that makes it worse. I think that makes it worse for you, not better, because the neighboring provision of the statute, as you quite correctly point out, expressly references the common law, and so at least a plausible negative inference is that when B doesn't mention the common law, that means B doesn't bring the common law along with it, because why do you specify that the common law comes along under C and then not say that under B? And again, the Virginia Supreme Court can construe Virginia law however they seem best, but I actually think on the face of the statute that you seem wrong to me about this.
I understand, Your Honor. I would just offer that in order to abrogate the common law, the principles of statutory construction under Virginia law are that must be an express abrogation. And there is no express abrogation in subsection B, that, hey, we are expressly saying common law principles do not apply to this right of indemnity. And so, because of that, you cannot make that negative inference. In fact, it's prohibited under the rules of statutory construction. And so the opposite is true, that the court must use the common law principles of indemnification in its interpretation of 414B. ANN's interpretation of the statute, in addition to being contrary to the plain language of the statute, is also contrary to the express purpose, as stated in 59.1-406, which addresses the scope of the act. The scope of the act, or the purpose of the act, is, quote, to promote the safety and protection of persons engaged in work or activity in the vicinity of overhead high-voltage lines. The purpose is not to insulate the owners of those lines from their own negligence, which is how ANN interprets this statute broadly in interpreting the indemnification provision. In fact, ANN's interpretation would be contrary to the express purpose, as it was disincentivize owners of high voltage lines from doing their part and fulfilling their obligations under the statute to promote the safety of the workers.
Yeah, but that seems really hard, because it seems that the obvious purpose of this statute is not to incentivize the owners of lines, it's to incentivize people who work around lines. And your argument, again, this isn't on the margins, but on this point, your argument gives people who work around lines less incentive, and their argument gives people who work around lines more incentive. And it seems, if we're going to talk about the purpose of the statute, I would say that this statute overall seems to be more concerned about people who work around lines than about the lines.
I agree that the purpose is for the people who work around lines. I also agree that the purpose of promoting the safety of those individuals is equally directed to persons responsible for the work, Allstate and Dietzel, and to the owners of the line.
Because one way you could really just easily interpret B and C together, or heck, this whole statute together, is, look, what C says is baseline. Any obligation the line owner already has, I want to be as clear as I possibly can. That's what C says. You don't get out of any legal obligations you had before this statute. We are not reducing liability for people who own lines. But everything else about this statute is expanding obligations of people who work around lines.
But the way that has to play out in order for there to be a viable claim of indemnification under the statute is that ANN needed to exclude the possibility that it was held liable for its own negligence. Because as Your Honor pointed out, Part C explicitly says we're not letting you off the hook for any other duties that you may violate, which may lead to injury or death to a person in the vicinity of high voltage lines. And that's
Well,
why
it actually doesn't, C doesn't say it doesn't limit their liability. It says it doesn't limit their duty or their degree of care. But then other provisions of the statute do in fact shift liability around in ways that would be different, right? I mean, in fact, that's kind of what B seems like, I mean, literally what B seems designed to do is shift liability around.
in certain circumstances.
Sure.
But the statute as a whole, 59.1414, through the language in C, which specifically emphasizes that common law duties and duties of care are still in existence. We also have the provision of 414A, which specifically, it identifies two circumstances in which ANN can still be liable. It says ANN or an owner of a line shall not be liable except for if they are not given notice and if they fail to do their part under the act. And then you've got Part B, the language in the actual indemnification subsection, which states that it provides indemnity only where the injury, quote, directly results from work in violation of 59.1408. So all three of those separate but complementary and comprehensive textual cues point to there still being a world in which ANN can be held liable. And because of that, and because the legislature is presumed to know the common law, and unless it expressly abrogates it, then it remains part of the scheme, then you have to look to the principles of equitable indemnification to determine whether ANN has pled a viable claim. And a prerequisite to recovery based on equitable indemnification principles is an initial determination that the negligence of another person caused the damage. The obligation that ANN took it upon itself voluntarily to discharge may or may not have even existed in the first place, because had it gone to verdict, it may have been the recipient of a defense verdict, as was MRA. It may have had its 414A defense heard and decided in its favor by the jury. Number one, was there even a liability obligation that needed to be paid? But number two, if it had gone to verdict and there was a verdict against ANN, what was the basis for that? Was it because as would be the only vehicle toward indemnification, they were being held liable because of the failings of Allstate or Dietzel? Or was it because of these separate degrees or duties of care that the statute explicitly says are still in existence? What A&N did here was settle with the estate for $800,000 prior to that prerequisite determination that it had liability, which therefore means under the law, as a matter of law, that it cannot seek indemnity for that payment. And to emphasize the point, as Your Honor has already alluded to, in the underlying state court proceedings, the estate alleged multiple other common law duties on the part of A&N, which it allegedly breached. It had experts, standard of care, common law duties, theories against A&N. If A&M was liable to the estate for its own negligence, under the parts of the statute that we've discussed, there would be no indemnity obligation. And so by choosing to settle with the estate before that determination of liability, A&N foreclosed its opportunity to seek indemnity under the statute or under the common law. I can't emphasize enough that throughout the litigation, A&N's position was that it could not be held liable to the estate for the exact reasons that it's coming before this court to say that it's entitled to indemnification, and that was under 414A. That its position all along was that it was not given proper notice of the work, therefore it could not be liable because other people didn't follow the act. It made a motion for summary judgment on that issue, it made a motion to strike, and a renewed motion to strike all at trial on this point, all of which were denied. It then chose to settle, which suggests that it knew it could be held liable for its own negligence, and so why not capture the risk at that time? But Allstate and Dietzel are not bound by A&N's trial decision to do that. The only way that Allstate or Dietzel can be liable for indemnification under this statute is if A&N is obligated to pay a debt for which they are not independently responsible. And neither of those things is true here. They were, number one, not obligated. They chose to pay the debt. It was a voluntary payment. It wasn't even a debt. They chose.
How is it not a derivative claim of the estate, A&N's indemnity claim?
With regard to the application of the workers' comp exclusivity provision?
No. Based on the argument, I think that one of the arguments they have is that this is a derivative claim of
The estate?
the estate.
Well, if it were, Your Honor, it is foreclosed because Allstate settled separately with the estate and was released. And so there can be no other claim. The release language foreclosed any other claim on behalf of the estate, which if this were to fall in that category, it would also have already been released by the estate or any of its agents or assignees.
Judge Benjamin, do you have any other questions? Judge Berner? Thank you very much.
Thank you, Your Honor.
Mr. Wright, you have some rebuttal time.
So if I may, Judge Benjamin, your question on how's it not a derivative claim, I think in some of the other OHVLSA case law that we've cited, particularly the Flint case, when people have said, oh, the workers' comp exclusivity provision bars it, the courts have said, well, no, the statute, it's akin, the statutory right to indemnification is akin to contractual indemnification. It's not derivative. And so I think that's the point here. I mean, the statute itself specifically says that they shall pay for all claims. And of course, on the workers' comp issue, just while I'm on it, the statute 59.1-414D, it says, except for the rights provided to the owner or operator of the overhead high voltage line in subsection B, that's under which we're suing for indemnity. Nothing contained in this chapter shall be construed to alter, amend, restrict, or limit the exclusive remedy provisions of the exclusivity provision of Virginia Workers' Comp Act. So I don't see how clear you could be, how more clear you could be that Virginia legislator specifically said that except for the indemnity right under which we're suing, this is not going to alter the Workers' Comp exclusivity provision. Well, we're suing under B, so it clearly does. To the point that my just going backwards to what Ms. Palmer was saying about we paid for something we couldn't be liable for, I think it's important to note that how important the OHVLSA is and how much it wants to stress and enforce its provisions by putting the onus on people responsible for the work to follow its provisions before and on the back end. So 59.1-414A says the owner or operator of overhead high voltage lines shall not be liable for damage or loss to any person or property caused by work within 10 feet of overhead high voltage lines unless notice has been given under the statute, and they subsequently negotiate temporary safety arrangements. Then B says any person responsible for the work who violates the requirements of 59.1-408, which is working within 10 feet of overhead high voltage lines and not following the OHVLSA's notification provisions, shall not be liable. This is belt and suspenders. They're working together. They're trying to say no ifs, ands, or buts. Person responsible for the work, you've got to give us notice. We're not on the hook unless you do give us that notice and we arrange temporary safety arrangements, and then we as owner or operator somehow provides them. We as an owner or operator violate those safety provisions. And then on the back end, just to make clear, you're going to indemnify us for all claims when you do work within 10 feet of overhead high voltage lines and don't follow the OHVLSA. It is a belt and suspenders approach to making sure the persons responsible for the work follow the OHVLSA. And you know, the onus is on them, the people responsible for the work. And it makes sense because people responsible for the work are the people who are going to know when they're working near overhead high voltage lines. I think my colleague, Ms. Palmer, Allstate, was talking about it's unfair to put this onus on the person responsible for the work and not the owner or operator of the line. I mean, going to the Maine case, the Maine Supreme Court said, look, it's perfectly reasonable to put the notice obligation under the act on the person responsible for the work and make them responsible for these claims when you don't follow it, rather than the negligent line owner, because they cannot be physically present where all lines exist and for whom fiscal responsibility could result in passing costs along to the ratepayers. I mean, this is a policy decision. All of this act envisions a whole process from start to finish, and then enforces it with this indemnification provision that we're trying to sue under now, to say that persons responsible for the work are responsible for notifying us and starting this process and ensuring it happens. And none of that happened here as we pled, and for that reason, we're suing for indemnity. To the argument about contract versus equitable, I think, again, going backward, this is when you're talking about derivative claim, go back to the Flint case in Georgia when they're saying, look, this is akin to contractual indemnity, which doesn't rely on the underlying person being liable. So sometimes you get people suing for equitable indemnity or contribution. The joint tortfeasor has to be also liable, and the joint tortfeasor who's an employer.
Well, what about her argument that if it's equitable, there is no determination of liability because you all chose to settle?
So I think that's two arguments she's got. She's saying it's equitable and it has to be, well, yeah, so you're saying the argument that it's equitable and there was no finding of liability on our part, and therefore, there's no finding of liability on Allstate's part.
Yeah.
And that's, I think that the point that this is not equitable is statutory, akin to contractual indemnity. We're relying on the statute. And then again, I'd go to the Maine case where they were suing the power company, and the power company was allegedly partially at fault, and they were raising that thing, and they're saying, look, it says all claims. This statute says you've got to pay for all claims. It doesn't matter our degree of fault. And again, it's not equitable indemnity, it's statutory indemnity. So that's the point on that.
But if there's no finding of liability, it goes to Judge Hyten's question about there being hypothetically no limit on the amount of the settlement, which seems like it could incentivize quite difficult results.
So, and again, this wasn't quite developed, but I would say, Judge Berner, that you have this in context of when you have contractual indemnity. I've had suits like this where somebody else is contractually obligated to indemnify us, we tender it, and they don't take up the defense, and they don't pay for it. And then
No,
we
but
settle.
under the indemnification provisions in a contract, there's generally an obligation to notify that the claim exists. Here, there's no obligation to notify. And so hypothetically, you could have a situation where the claim is settled for $1 billion without that being the actual value of the claim, and then the indemnification obligation kicking in.
Hypothetically, yes. I mean, I think the act is very strong that you pay all claims. I think that's not what we've pled here. I think we did give notice when pled it's reasonable. But I mean, again, I think the act is very strong, and it's strong on purpose that you pay for all claims when you don't follow these procedures.
So you think the act reads in a notice requirement that doesn't exist here?
Well, let's not miss the forest for the trees. This whole thing gets started by statutory notice under the OHVLSA that in terms of working within 10 feet of the line. You're talking about notice of a potential claim.
Yes.
So I don't think it reads, I think the statute says what it says, and it doesn't say anything in here about when you've got a claim to give the other person notice of the.
I agree. It doesn't say anything about that. So
Yeah.
that's why it's really not analogous to a contract.
Well, the reason I was, again, it doesn't say that, just other courts, when they've dealt with the workers' compensation bar issue, where when you either have contribution or equitable indemnification, the other person has to be found at fault, or at least partially at fault, for something that you've got to pay for. And that when that other person is an employer, and the exclusivity provision of the Workers' Comp Act bars a claim against them, they can't be found at fault. And they get around that by saying this is akin, statutory indemnity, it's akin to contractual indemnity that doesn't have that problem. I think perhaps in a similar way, you could say when this is akin to contractual indemnity, you deal with those situations where in a suit for contractual indemnity, the other people say that you paid too much, or the settlement wasn't reasonable, and it just wasn't really developed in the briefing, and I think some of what happened in the case, the court below is not quite in our pleading in terms of we're at 12b6 posture. You'd go through some of that case law, and there is case law out there when you have contractual indemnification suits about whether or not the settlement they paid was reasonable, whether or not you gave them an opportunity to take up a tender of defense and defend it themselves, or they're stopped from saying it's unreasonable because they didn't defend it themselves, all that stuff. I don't think we're there right now, but it says what it says, and there's no notice provision, and it says all claims. So, I mean, I think that's just the way it is, and it's strong. And it's important because it tries to ensure that people follow the act. So thank you, and for that reason, I think the court should reverse the district court.
Thank you, counsel. I'd like to thank all three counsel for their arguments and for your patience with the delay caused by our Banc. We will adjourn court for the day and come down and greet counsel.